Chairman, we're live.
Okay, welcome everybody in the audience and those on YouTube. Today is Friday, June 28th. This is a continuation of Board of Equalization procedure. The first one up today is SL 2404.
Are we going to do the part?
Oh, gosh. Thanks, Sherry. I appreciate that. Before we start, would everyone please rise and follow me in the pledge? I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thanks for the gentle reminder.
Absolutely.
Okay. So now we're going to go in and announce that our first one for BUE this morning is SL 2404. This is the Girl Scouts of Silver Sage Council Incorporated. The way this kind of works today is we're going to try and roughly estimate about 60 minutes for this hearing. We may or may not make a decision today, but we will notify you by paperwork by July 8th of our decision if we don't make a decision today. Just a reminder that this hearing is being recorded, so be careful what you say, what you do.
Please use the microphone.
Yeah. And the objective today is we're going to listen to your arguments and then consider the evidence presented and then what kind of agreement you've made with the assessor and go from there. So as we get into this, the first thing I'm going to do is ask if anyone on this board has any ex parte or conflict of interest. I do not. And I do not. So at this time, I need you both to rise. Oh, everybody to rise. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, please let the record show. Before we get into it, can you please state your name for the record, your full name?
My name is Sarah Berry. I am of counsel with Holland and Hart based in Boise, and I'm here on behalf of the Girl Scouts of Silver Sage Council.
Okay.
My name is Faustine Moulton. I am a summer clerk with Holland and Hart, and I am mostly here to observe.
And it's Moltin?
Moulton.
Ton, okay? Thank you very much. So the way this will work is you guys are given kind of 15 minutes to present your case, and then we'll ask you questions, and then the assessors are allowed to give their 15 minutes, and then we kind of have a general back and forth at the end, and we'll see where it goes. So we'll let you guys go first.
Thank you. We appreciate you having us here this morning. I'm going to abbreviate to the Girl Scouts instead of Girl Scouts of Silver Sage Council, if that's all right.
You bet.
So Girl Scouts have owned the property on Pilgrim Cove for many decades. There were some issues back in the 60s with changing their name, with becoming a joint entity with multiple different Girl Scout organizations. So the property is still titled to Boise Girl Scouts. Boise Girl Scouts merged with other Girl Scout entities back in the 60s and became eventually Girl Scouts of Silver Sage Council. There was an attempt made back in the 60s to transfer title. It was ineffective. So I recognize that this Valley County and this board asked the Girl Scouts to fix that issue last year, and they didn't get it done. In order to remedy that issue, we have filed a quiet title action here in Valley County so that we can legally transfer title from Boise Girl Scouts to Girl Scouts of Silver Sage Council. That process is going to take a month or two. We have to serve notice of the lawsuit by publication because Boise Girl Scouts doesn't exist. So once that service by publication is completed, we will hopefully default and get title transferred, at which point we will no longer have the issue of who owns the property.
Right.
With our submission is a copy of the complaint that was filed earlier this month, and we received the order from the court to serve by publication yesterday. So that process has started.
And I have seen your ad in the Star News.
Fantastic. So we've got it going, and we will see that through to completion and make sure we get title transferred. So that was the direct reason for the denial of the Girl Scouts tax exemption, and we would ask you to reverse that and give a reverse that denial, grant the exemption, and give us time to complete the process so that we don't have to deal with this ever again.
Ever, never, ever.
And that's two.
We'll save everybody some time. I understand that the Girl Scouts have been in contact with Ms. Leeper to discuss the exempt days versus non-exempt days, the commercial uses of the property versus the nonprofit uses of the property. And we are in agreement with the calculation of 66 days. I don't know what the full calculation looks like from there, so I would have to wait and hear from.
Packet right there.
And I've read through that, but I don't do math on the fly. So I'd like to wait and hear from what the assessors have to say on what that calculation will end up looking like.
Well, you're just making this really easy, Sarah.
Really easy. They've been amazing to work with, all of them.
Okay, anything else you want to add? Anything else? Faustine, you want to add anything?
No, sir. Thank you.
You're just observing.
Just here to take notes.
Okay. So then, any questions for the appellant?
No, that's pretty clear for me.
So then we'll move it on over to the assessor side and let her give us what her recommendations are, and we'll go from there.
Okay. So the subject property is located at 2111 Pilgrim Cove Road in McCall. Christy has it up there on the map for you on Payette Lake. The Board of County Commissioners denied the original application because the owner of the property did not match the applicant's name. The Girl Scouts submitted an affidavit of ownership and provided the filing with the 4th Judicial District Court of the State of Idaho in and for the County of Valley, case number CV 43-24-00222 on June 14th of this year. We would request that the Board of Equalization reverse the denial of the exemption and consider a partial exemption for the Girl Scouts of Silver Sage Council Incorporated. I went over the 2023 calendar of events with Stacy Roth on June 25th of this year. We are recommending the following: 299 days of exempt use and 66 days of commercial use. That breaks down to the land value. The full land value would have been $11,804,388. I divided that by 365 days to get a per day assessed value of $32,340.79. I multiplied that per day rate by 66 days and came in for an assessed value on the land of $2,134,492. On the improvements that are on the property, the improvement values for the full year were $1,821,296. I divided that by 365 days and came out to a per day assessed value of $4,989.86. I multiplied that by 66 days, and it comes into $329,331 on the assessed value for the improvements. So the land and improvements totaled together came in at $2,463,823. I included Idaho Code 63-602C in your packets. And this is going to pertain to the partial exemption of the property. The property must be used exclusively for the purpose for which such limited liability company, corporation, or society is organized for. So in other words, if they rent that property out to someone else, it becomes a commercial use.
Sue, did you include the calendar?
It's towards the end of the packet.
So did you calculate what their taxes would be for this property?
No, I did not.
I didn't see that in this one.
We calculated the full amount of taxes, just an estimate. If you guys need an estimate on what the partial would be, I can do that for you and email it to you.
We would appreciate that.
Yep. It's going to be, I have to use 2023 levy rates because the 2024 levy rates haven't been set yet. Okay? On that very back page was my list of the days in question. And those are the ones, we went over the entire calendar.
The very last page?
It's just my handwritten notes.
Oh, I don't
Looks like
think I have
this.
that. This is.
It's behind it's behind the calendar for the Girl Scouts.
Oh, it is,
Did you find it?
yeah. With the last,
Sure.
the very last, the calendar. Oh, yours is-
I also included the IDAPA rules for how to calculate the commercial use days. And I also included the Confluence Institute BTA decision from 2021 versus Custer County to give us guidance on how to construe whether they're exempt or if it's a commercial use.
Okay,
I also included the process that we used to determine 602C exemptions and in our office for your review. The next pages are just pictures of the website for the Girl Scouts. They host weddings and what have you for commercial. That's what we're considering a commercial use. And then, of course, I included the calendar for you. And then the list that I went over with Ms. Ross. And that's how we determined how many days, and we both were in agreement.
okay, any questions for the assessor? No.
So you are accepting their application to change that title?
Yes, I absolutely am. They filed another affidavit, and also they filed with the court here in Valley County to quiet the title. Those proceedings are in motion. So,
This is an approval.
excuse me?
This will be an approval.
So I am requesting that you reverse the complete denial
Okay.
and
Need to sign.
consider the partial exemption,
That's right.
giving them 299 days of exemption and 66 days being assessed and therefore taxed.
Have any further questions?
No, I do not. Thank you.
Ready for a motion then?
Yes,
Mr. Chairman, I would move that we reverse the denial and approve the partial exemption for the Girl Scouts parcel appeal number SL 2404 with 66 days as commercial and 299 days exempt.
a second? I got a motion and a second to reverse the denial and approve the assessor tax days of 66 for commercial, 299 for exempt. All in favor, please say aye.
Aye.
Aye, motion carries. There we go. Great, thank you very much.
Thank you.
Okay,
I apologize. I called you Sarah Moody, not Sarah Berry. I apologize.
That's all right. There are only a few Sarahs in the state of Idaho.
Right. No, thanks for all your hard work in getting this going. We appreciate it.
Thank you.
all right, you guys have a great day.
Thank you. You as well.
Ms. Berry, just for your information, a formal letter will be submitted to you by the prosecuting attorney's office, probably more than likely by July 8th.
Okay.
What we're proposing to have.
That's our goal.
All right. We'll keep an eye out for that. I appreciate it. Thank you.
Thank you. Okay, we are not scheduled to hear Trinity Pines until 10 o'clock a.m. Are you Mr. Peterman?
I am.
Hi, I'm Sue Leeper.
It's Randy,
Randy, are you expecting anyone else or just you?
just me.
Just you? Is that appropriate for us then we'll take a little bit of break and then we'll start here a little sooner than 10,
That'll be fine.
okay?
Thank you.
So let's go mute Doug until 9:30.
Mr. Chairman, we're back on.
Okay, welcome back, everybody on YouTube and those in the audience. This is the second agenda item for our Board of Equalization agenda today. This is SL 2411, the Nazarene Church, AKA Trinity Pines. So at this time, I want to kind of state some of the rules of this, how this hearing will work. We're going to roughly give about 60 minutes for this hearing. We may or may not make a decision today. This hearing is being recorded, so it's important that only one person speak at a time for clarity of the record. Our objective today is to listen to the appellant's arguments, consider the evidence, and determine whether the original decision should be upheld or modified. So before I open this up, I'll ask if anyone on this board has any ex parte or conflict of interest. I do not.
I do not.
And I do not. So at this time, Mark, if you could stand and or first of all, introduce your name for the record.
My name is Randy Peterman.
Randy, sorry.
I always hate to admit this, I'm an attorney from Boise. I'm with the firm of Gibbons Pursley, and I'm here on behalf of the Intermountain District Advisory Board, Church of the Nazarene, and Trinity Pines.
Okay, and if you raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. You may have a seat. The way this will work is we're going to give you 15 minutes to present your side of the
15?
case. Yeah. And then we'll ask you questions or concerns, and then if there's no more questions, then the appraiser or assessor is allowed to do her 15 minutes, present her case, and then towards the end, we'll kind of have probably some back and forth concerns. But so at this time, sir, I'll turn it over to you.
I'm going to try to move out then because I have some issues. Exhibit 1 is a provision from IDAPA. IDAPA is the regulations, a portion of which were issued by the State Tax Commission. And basically, this IDAPA provision says that the county needs to use identical processes as to religious entities and charitable entities under 602B and 602C. Exhibit 2 is a comparison of what happened in Valley County in 2024. Church camps, there were 11 applications submitted, 2 were granted and 9 denied. That's an 18% approval rate. We move over to the back of that page. This is for charitable organizations, and 16 were submitted, 15 were granted. That's a 93% approval rate. I'm going to skip over those 2 and go to Exhibit 3, please. Exhibit 3 is the application form that was submitted to Valley County by Trinity Pines. One issue here is that when a church camp submitted an application, it was asked 50 different questions. That's what shows up here. When we get to the ones for charitable organizations, there are 10 questions on 2 pages. And part of our argument is that doesn't fit within the IDAPA rule. The other thing, if you go to the last page, is that Trinity Pines submitted its application and then was asked in an email to provide a daily calendar for 2023, and then was asked to provide data as to who is using the campground. That's how the religious entities were treated. That is not how the charities in Valley County were treated. And we'll get to that in a minute. Exhibit 4 is the letter from Valley County to Trinity Pines. I would note that I had a conversation with Sue Leeper, and the figures have changed a little bit there. I want to go to Exhibit 5 because this is where we really get into the substance of what went on. This is, the front page is the letter from Valley County to the American Legion. And let me say, I don't have anything against the American Legion. I've been in that building and everything else. But as opposed to the 50 questions that were sent to the church camps, here we have the application that was sent to the local charities, and there are 10 questions. That's it. 50 questions versus 10 questions. Another issue here is that the legal owner here is different than the entity that's using it. And that is shown on paragraph 6 of the application. The American Legion Inc. is the owner. And the local Post 60 is the party that uses it. Two of the requirements under either 603B and C are that the party applying own the property and then the use of the property. If I understand it correctly, for use, Trinity Pines was analyzed, and if a use was with anything other than a Nazarene entity, that was counted as a commercial day. So if we go over to what's called the property tax exemption worksheet, under 4A, the name of the person or organization that leases or uses the property varies annually. D, the amount charged daily, monthly, or annually to the person or organization leasing or using the property, $175 a day. So on the one hand, we have Trinity Pines that answered a 50-page questionnaire, submitted hundreds of pages of documents, was then sent an email by Valley County saying, give us a daily calendar, and then another email that said, tell us the use from the daily calendar. Trinity Pines did all of that. Where is that here? Where is the email from Valley County to the American Legion that says, well, wait a minute, you're saying you lease your premises, you don't own it, you're saying that you lease it, but there's no further inquiry. They just get the one-page, very short letter that says, you're granted your exemption. That is really contrary to IDAPA and what was intended as between religious corporations and charitable organizations. I would note that Ms. Leeper looked at the internet page for Trinity Pines, and I'm not sure that we ever made that a part of the record, but if you go to Exhibit 6, had the assessor looked at the use of this property for the American Legion, you can see that once or twice a week, they're making a commercial use of the property. And so I'm just making the point that the rule applied by Valley County as to the church camps is very different than the rule that was applied to charitable organizations. Exhibit 7. If you go to the second page, again, this exemption was granted under 603C. If you go to the third and fourth page, there wasn't even any material submitted, and yet they were granted the exemption. Why would that be? There's nothing. There is, the application, there's nothing. There is in the property tax exemption worksheet, very, very minimal information. But why was this charity granted its exemption without question by Valley County? Exhibit 8 is the Long Valley Preservation Society. The materials indicate that there was both a approval and a decline of this charitable exemption. I'm not sure what happened there. Cascade Golf Association, and again, I don't have anything against the golf course here, but in that case, the exemption was granted. The property tax exemption worksheet is not fully completed. There's no IRS certification, no deeds, bylaws, income and expense statement. This property is leased from the BLM and to the city of Cascade. So how does Cascade Golf Association qualify? It's not the owner, and it makes income from leases. When Trinity Pines made income from leases, those are counted as commercial uses, not here. And there's a real disparity between how the church camps were treated and how the charities were. Exhibit 10, Heartland Hunger Center. And I'm just going to skip that, if I may. Exhibit 11, and look, I don't expect Valley County to be familiar with this Religious Freedom Act. That was enacted in 2000 by the Idaho legislature, and it creates super rights in favor of parties who are exercising their religious beliefs. And if you go through this, you'll see that under subpart 4, it does apply to this county. If you go through the bottom part, it basically says that government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. In other words, and I don't have time to go into the case law here, but the Idaho Supreme Court and the Federal District Court have both ruled that this creates protection for religious organizations to exercise freedom of religion as they wish. And it's a very, very low bar, the way the cases have interpreted it. It also provides that a party asserting a right under this Religious Freedom Act can recover costs and fees from the governmental entity. And again, I knew this was here, but I wasn't familiar with it. And once again, I'll admit I'm an attorney. But this statute trumps. It generally applies to any action taken by a governmental entity, including a county. And it trumps even what 603B and 603C say. And if we go back to that Exhibit 2, where 19% of the church camps applications were denied, 93% of the local charities were granted the exemption. Why is that? Does that really reflect what the Religious Freedom Act is intended to protect? The last exhibit, ladies and gentlemen, is the county relied upon a specific decision from Custer County. And that decision came from the county commissioners sitting, I think, as the Board of Equalization. This, Exhibit 12, is a much more recent case. May 1, 2023, is from the district court. And in that case, the district court said to the assessor, "You didn't do this right. So I'm granting the exemption." And again, as an attorney, I guess I wonder why there was so much reliance on a case that's years old, issued by the Custer County commissioners, when from the same county, more recently, we have a case from the district court that says you were too strict. And it doesn't even rely on the Religious Freedom Act. It relies on other issues. So, in closing, it's been a tough 4 years for the church camps. COVID, 2020, and 2021, 2022. All of the exemptions were denied, and then on appeal, not on appeal, but this entity reversed them all. This year, we've been hit with the tax. And I think, at the risk of sounding cynical, I think I would just say, if Valley County wants to increase its tax base, why doesn't it add another 2 cents per $10,000 of value to all those people up on Fayette Lake? Instead of imposing these costs on the camps and the kids. Trinity Pines does not allow cell phones in children or teen camps. We've been told that by several children. That's the first time they've ever gone 5 days without a cell phone. And to me, that is the value that's involved here. And to deny the exemptions, it's not Idaho, it's not Valley County. We love it here, we've invested a lot here, but we would ask that the exemption be granted in full. Thank you.
Okay, not quite sure where to start, Randy, but I think there's an issue. The biggest point of your argument is the difference between how we treat religious versus charitable exemptions. And the code really spells out what we can and can't do for both. Of course, as you pointed out, the charitable is a lot less questions, maybe less documentation than the religious side of it. But I want to state up front right away, we are not denying anybody's right to practice religion. That is not what we're here for today. The issue stems a lot from the understanding, and we tried to notify a lot of the church camps last year that this was coming, research and understand that how the law has changed, how court cases have changed, how the counties are to treat these different applications. And so that's caused a lot of consternation with the church camps this year. And I think that it's really, to me, it's a business decision on that church camp whether or not they want to continue with non-religious uses of those camps. The second point I want to make out is that whether you're exempt or not, everybody still demands a share of EMS fire if they need that service, which is a county-funded, taxpayer-funded organization. And I think that that's important to state that the commercial camps pay tax and contribute towards the cost of those services that the county has to provide. Go ahead.
I want to weigh in too on your comment about, increasing taxes. This doesn't increase taxes. It doesn't change our budget one bit. It changes who is paying those taxes. And so it's tax shift. If you're not paying for those commercial business days, then the citizens of Valley County are paying your share. And that's what we're trying to make sure, that there's equity in the tax system, which I would assume is exactly what the legislature was trying to do when they put these rules in place. So we have nothing to gain by this as far as the county. And I want to clarify that for our residents. It's not we're after grabbing money from church camps. We fully support our church camps. It's when they cross that line from being a church camp to a business entity that is in question. And so that's what we're trying to, that's what this board is about, is listening to why you are not a business entity when you invite others in that are not religious affiliates of yours.
Could I respond, please?
Oh, sure.
I think I must have come across wrong. I'm not stating or implying that there was any bad intent or anything by this group, okay? And if I came across that way, then I apologize. You indicated that there's been a change in the law. There really hasn't been a change in the law. And your own materials from Sue Leeper cite to ADAPA, and it says to value the taxable part of any otherwise qualifying property exempt under section 63-602B, Idaho Code, each county should use comparable methods to those being used to value the taxable part of qualifying exempt property under 602C. There's supposed to be an equality. And at least as to last year, I am maintaining that equality did not occur. What happened was that Valley County changed the manner in which it computed an exemption. And it went to this counting days idea. And I think I understand it. If a day at Trinity Pines was devoted to a Nazarene church camp, it was exempt. But if it was devoted to any other use, including any other Protestant church, it was commercial. because of the idea of rent. I've been a Protestant my whole life. I can't figure out the difference between what I understand are 20,000 different Protestant religions. But if you had 100 people at a church camp sponsored by the Church of the Nazarene, 51 were Nazarene and 49 were Buddhists. Is that a commercial use? I don't know. What if 49 were Nazarenes and 51 were Baptists? And it seems to me as though what happened with Trinity Pines and other church camps is that the benefit of the doubt went against them. That's not what IDAPA says. That's not what the Freedom of Religion Act says. And it really leaves unsaid why these other charities were granted exemptions like that. We submitted hundreds of pages. We submitted a daily calendar. We submitted a statement as to the daily calendar and who did what. And yet when we come to these local charities, it just doesn't happen. And in some cases, they don't own the property. In some cases, they admitted on the very short handwritten form that they did make commercial use, they did rent, but there was no follow-up from the county. And that's why I say I don't think the law has changed. I think what's changed has been Valley County's view of the exemption under 602B and a decision to apply different standards under 602B versus 602C. I agree. I understand that county services are available and have to be. I guess my response would be that if the state legislature didn't want to provide exemptions, and there are like 42 of them, then it wouldn't have done that. But the legislature saw something beneficial for a religious organization. They saw something beneficial for an educational property. They saw something beneficial for a charity. So I don't feel like I'm here arguing that this commission should make that policy decision. The policy decision has been made. And if you go through 63-602, I think it goes all the way to TT, A through Z, AA through TT. And that's the policy. That's why the IDAPA says what it does. And that's why the Freedom of Religion Act says what it does. Thank you.
Okay. Any more questions for the appellant?
Not at this time.
So then I'm going to turn it over to Sue. Go ahead.
I have a few questions. Randy, can people use the RV park or camping area without being a part of a conference at Trinity Pines?
We use the RV park and the camping area solely as housing for volunteers. We rely heavily on volunteers, probably as many as 20 during the summer. And a lot of them like to haul their RV up there or their trailer and stay there. And we don't charge anything. We're providing them a place to stay. So we don't allow any public use. We don't compete with the RV camp that's on the left as you drive into Cascade. So
Okay.
no, we don't compete with any other private entities. We aren't paid for it. It's a service provided to our volunteers.
Okay. How often was Camp Lowry area used by the scout groups?
I honestly don't know.
Okay.
I can tell you that there's a Boy Scout troop that asked if we would license, here I am sounding like an attorney again, license a part of the campground so that they could use it. It's clear up, this is 200 acres, and it slopes up and it's clear up in that area. We don't charge rent or anything else. Again, it's just a part of our ministry.
Okay. Was Trinity Pines used for any weddings during 2023?
I honestly don't know. I think there have been occasional weddings out there, but, and I can tell you that I'm going to have my ashes spread out there when I pass away, which this group may hope happens quickly. I don't know. But I just don't know the answer to that. I'm sorry.
That's okay. Does the conditional use permit for Trinity Pines include weddings or large conferences?
I'm so old, I was around when we annexed that property into the city. We got city sewer, we got city water, we did the conditional use permit. And as I recall, it was relatively broad.
Okay.
It was, and we also, it was annexed into the city, but it was zoned as a camp. And that was very important to us, as was the water. I mean, City of Cascade has a water tower up above our property. And for 40 years, we could not get water from there to our property because it crossed a party's property who didn't want to cooperate. I don't know what you guys thought about Ben Wellington. To me, he was a character. But Ben had been up there and gone into that place and fixed a lady's dishwasher at midnight one Friday night. So when Ben went and asked to get the easement, we got it.
Nice.
And because of that easement, it used to be that the water line would just deadhead out Cabarton Road, and the pressure out at the end of Cabarton Road was awful. When we did that, we paid for it, and we connected so it became a loop. That's that little block building on the right. That cost us a lot, as did the sewer line. We were within about 3 feet of having to create a lift station. And I thought the only way to get sewer out there was along that railroad. I called the railroad company in Texas. I said, would you give us an easement? They said, yes, but it costs you $4,000 a year. And I said, well, I can't afford that. What if I just have an appraiser reduce $4,000 a year for 30 years down to present value, and you can gift us the easement because we're a charity, we're a religious organization. They did it. And so we feel as though we've benefited the county and the city through those actions.
Wait, do you have any idea if the conditional use permit covers the standalone RV park?
I can tell you that each and every time that we have made an improvement, we've completely gone through the City of Cascade process. And I have not been involved in that just because I don't get involved till there's a problem. So I believe it did. It's a form of camping. But I can't tell you specifically.
That's okay. Okay. The other thing that I wanted to just bring to your attention, it seemed as though you thought that the Board of Equalization in Custer County had that, the Sawtooth Chapel. It was actually at the state level, so the Idaho State Board of Tax Appeals, and it was a 2022 decision that we're looking at. It wasn't a Custer BOE. I just wanted to clarify that.
Well, I must have gotten that wrong.
Yeah, that's okay. As for, I noticed most of your exhibits refer to 602C applications. When you put in your 13-page public records request, it was, as you know, it was all hands on deck for all of the 10 days. And I'm wondering if maybe some of the documents, maybe you didn't associate with the entities that you have mentioned in your binder, perhaps you maybe didn't find them. I assure you, we had a list of criteria to look at 602B exemptions. We gathered those questions and put them on the application right out of Idaho code to be able to answer those questions. Whether it was a 602B application, we would look at the 602B code, and the same for 602C, which the codes are a little different.
Okay.
We are not picking on religious organizations. We are just trying to apply Idaho code. And when it comes to applying IDAPA rules, and you and I are referring to the same
Right.
IDAPA rule, so we must first look at Idaho code. And if it appears that there's a commercial use, then we use the IDAPA rule to calculate how to calculate the assessed value on that. And we apply it the same to 602B as to 602C. I just want to make that clear.
Okay.
That's all.
if I had had more time, I intended to indicate that most of the exhibits I have are courtesy of the Freedom of Information Act request that I made to the county, and the county did a really good, and Brian did too.
We tried.
Yeah,
Very,
they
very
did
hard.
a really good job of responding in every way.
Yeah,
And
thank you.
I intended to say that and to acknowledge that. I would still note that if we look at Exhibit 2, there is a real disparity between the approval of the exemptions under E and C, and I'm not sure how this IDAPA provision, if it was applied, why that would be. Why are 93% of the charities granted an exemption? Why are they given a 2-page exhibit with 7 or 10 questions versus 50 that came to the likes of Trinity Pines? Why was Trinity Pines asked in 2 different emails to give a daily calendar and then to differentiate use under the daily calendar? That wasn't asked of the VFW. That wasn't asked of any of these other parties. It was just, it's done. And it would seem to me like equality of treatment, at the least, involves equality of questions and information from the county, whether it's a B or a C entity.
Agreed. And I'd like to clarify, Christie reached out to every single organization that submitted an application for exemption, whether it was 602B, C, D, E, or GG. And a lot of the information she was able to get on the phone. So we did treat everyone the same. If she wasn't able to get them on the phone, because obviously, for me anyway, when I go over a calendar with someone, I like to be able to ask specific questions on each line item. So if she wasn't able to get them on the phone, then she would send an email. Whether it got answered or not was up to that entity. So I want to assure you, we treated everybody absolutely the same.
And I know that I come across as being critical here. I don't intend to be. By the same token, I have a duty to my client to advance the best arguments I can. I have no issues with the Freedom of Information Act request. I did it on a very short time frame. It was a massive document, and I very much appreciate that, okay?
Yes.
Because that's kind of how I put my exhibits together. At the same time, I don't know of any county in Idaho that is even looking at the Religious Freedom Act. Nevertheless, it applies. And I also agree that if it were carried to its illogical extreme, that Freedom of Information Act could gut a lot of what government does at any level. This statute is the Idaho statute. There is a federal statute that originally said it applies to federal and state governmental entities. The U.S. Supreme Court said, no, you can't do that to the states. That's when Idaho went out and enacted that Freedom of Religion Act, which is really the most aggressive in the country. It goes well beyond the protections a religious organization is entitled to under the First Amendment, the Fifth Amendment, the 14th Amendment of the U.S. Constitution, or the state constitution analogs. It's there. And it isn't as though you have to jump over something this high under that act. I have to jump over something this high. And that's the point I'm trying to make.
Mr. Peterman, I would have a response or a question for you. So we have looked at the act, very familiar with it.
Okay.
We've looked at it for all of the church camps. And I think the question becomes when the religious entity steps into the business realm. And that's the question that we are trying to ascertain today. Is there business creep going on in the church camps in Valley County? And that's one of the questions that we have before us on all of these, is that when you start competing for event venues and wedding venues and those types of things, you're competing in a non-religious world. We're not in any way, we're all very religious. So, I mean, we don't want to step on any religion of our camps up here. But when you start creeping into the business realm, we totally understand why, because you know, you gotta fund these camps. And you're trying to do the right thing. We all understand that. But we also, as commissioners, have to make sure that every one of our entities, and all that we do is legal. And so we have to look to the legal means that we have. Case law has really been clarified in the last few years. That's why this conversation is coming up now. No, the law hasn't changed. The interpretation of the law has. And as you know, every single lawyer that comes in front of us has a little bit different interpretation of the law.
But
As we
mine
do.
is the best, isn't it?
Um,
That you've seen in many a
It's
year.
certainly different, let me tell you. This is the first time we've been hearing some of this. So we are certainly not questioning the religious intent, any of that. It's when a religious organization, and my family was totally involved in Camp Cascade for generations. And we ended up having to bring in other entities. We had to end up opening up for business purposes to be able to fund our camp. And that becomes a business purpose. Once you step over that line and you start competing in the realm of individuals that are out there also trying to do exactly the same thing, they're paying tax, the religious organizations are not, but that doesn't relieve you from tax payments. When the organization has a business plan that we have to start charging and bringing in more people in order to pay for the camp, we totally get it. But it doesn't change our interpretation of that law either.
I understand that, and perhaps I should have come here to learn about the Religious Freedom Act before I made my own interpretation. I don't know. You guys are really up on things, and I respect that.
You know, we're just trying to follow the law, and
I know.
we got a great guy back there that's keeping us
Yeah.
online.
Yeah, I hear you. And, you know, Brian and I were talking, I represented the Department of Agriculture about 30 years ago, and he was there, and we have a long history, and we love Valley County. You know, we camped on an in-holding inside of Ponderosa State Park on a lease from 1937 till 2000. And we only had a summer camp. And the lease rate went from $700 a year to $93,000 a year. And the state was saying, you may need to allow uses that are contrary to what your religious beliefs are. That's why we came here. I spent, state tax, the state land board owned that 4-acre campground that was an in-holding. We were right on the lake. I mean, it was beautiful. I spent 6 years circumnavigating Valley County. I didn't make it out to Yellow Pine, but I was with officials, and we were looking for a new place. And our dream was to have a year-round camp and to offer it to other than Nazarene people. So that's our mission, and I think that mission has to be considered when this body looks at that Religious Freedom Act. If I can find it real quick.
And Trinity Pines is a beautiful addition to our community. And this is nothing against Trinity Pines. It's Trinity Pines is having to make some business decisions, a business model that may then include taxation. And what it, you know, I mean, if we are to provide government services, everyone should pay their fair share when they actually are in the business world. And that's where we're trying to clarify. It's nothing against Trinity Pines. You guys are a great addition. It's when does the line cross to be in the business world versus truly being a religious camp?
And when that analysis leads to whether Baptists are out there or Nazarenes or what Episcopalians, whatever.
We agree with that, but the law specifically says for the benefit of the owner.
No, the law specifically says that you cannot treat that place different if there's an alternative to what you're doing. That's what the Religious Freedom Act brings. And the standard there is, it's this high, it might be this high. Does it involve a deeply held religious belief? And does it avoid the county getting into fine distinctions between religious beliefs? Well, when you are saying that my camp with 100 kids, 51 are Nazarene, 49 are Buddhist, that is a religious use, and if they're flipped, it's not. Who decides if the Nazarenes are very related to the Missionary Alliance Church? They're no different. Or closely related to the Baptists, and they are different. They have totally different backgrounds. And if I was running a Roman Catholic camp, the Pope sits in Rome, in the Vatican, and makes decisions. It's a top-down deal. Protestants, I had a friend once that said, hey, if 3 people get together, it creates a Protestant church. And I said, yeah, I think that's what Jesus said in Matthew. Where 2 or 3 are gathered together, there I will be also. It's a totally different view of religion. But when the county is coming in and making distinctions between religious beliefs, when the camps there they're not homogenized. They're not all Nazarene. And to make that decision, it really involves the county making some fine distinctions, which I don't think are allowed under the Religious Freedom Act.
And just to back up from what we're reading and what the legislature gives us, is that we're not making those distinctions. Legislature put in there just 2 words in there. It says the owner. And when they put that in there, they made a distinction that camp is only used by the owner, which is Trinity Pines or Baptist camp or whoever. When they put those 2 words in there, it delineated how we have to make our decision. We'd love to do it a lot different, but that's what the law is delineated to us.
Okay, well, let's move on. Sue, you want to go ahead and do your side of it now?
I just have a comment though off of what Randy was saying. So to help you understand the way we looked at it, from the distinction. So if you're the owner of the property and you use the property for the purpose of which you were organized for, then the use is considered exempt. Okay? If you rent the property to someone else or let someone else use it, even if you don't rent it, it becomes a commercial use because someone else is using the property, not the owner.
Do you mind telling me where is that case law? Is that IDAPA? Where is that from?
It's actually in the code. If you break the code down and just read it one sentence at a time and absorb it, it does say for the purpose.
It's 602B, number 2.
Mm-hmm.
But that is what IDAPA is still good law, whether I disagree with it or you do.
Well, it's a rule to help us
That's right.
understand the code.
But it does have the force of law. It's not a statute. I agree with that. If you look at the federal government, they got millions of pages of regulations.
Mr. Peterman, I think it's Sue's turn.
I apologize. I'm sorry.
So in Idaho Code 63-602B, number 1, the following property is exempt from taxation: property belonging to any religious limited liability company, corporation, or society of this state, used exclusively for and in connection with any combination of religious, educational, or recreational purposes or activities of such religious limited liability company, corporation, or society. So meaning for the owner, including any and all residences, blah, 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 blah. In number 2, it states if the entirety of the property belonging to any such religious LLC, corporation, or society is leased by such owner, or if such religious LLC, corporation, or society uses the entirety of such property for a business or commercial purposes from which a revenue is derived, then the same shall be assessed and taxed, as any other property. If any such property is leased in part or used in part by such religious LLC, corporation, or society for such businesses or commercial purposes, the assessor shall determine the value of the entire exempt property and the value of the part used or leased for such businesses or commercial purposes, that part should be, sorry, I skipped a line. Part used or leased for such business or commercial purposes shall be taxed as any other property. So if you lease, rent, let someone else use, another organization other than the owner of the property, we are viewing that as a commercial use. And so once that's determined, then that's where we look to that IDAPA rule to tell us how we are to assess and therefore tax that property. So that IDAPA rule just gives us guidance on how to calculate the days of commercial use, which it mentions valuing the taxable part of qualifying property. Under section 63-602B, number 2, Idaho Code, a county will determine the value of the part of the property used or leased for business or commercial purposes by considering the particular facts of each case, examining the amount of time during the calendar year the property is used for business or commercial purposes. And then it goes on to say that we'll treat and calculate 602C exemptions the same way. And we did.
Let's go ahead and you present your argument on your side.
Okay, so Trinity Pines is located at 349 Cabarton Road in Cascade. The property is better known Trinity Pines Conference Center. The Board of County Commissioners had granted an exemption of 147 days. Randall Peterman filed an appeal on June 24th of 2024. Christy Hamilton went over the calendar again and realized when we were preparing this appeal that some of the groups that use the property for commercial use overlapped. And so when she went back and recalculated those days so that if we had 2 commercial uses on the same days, they only got counted for 1 day rather than the way it was originally calculated. We apologize for that. So after we recalculated the number of days that the property was used for a commercial purpose, I would actually like to request that you modify the number of days to the following. Exempt use modified to 208 days, and commercial use modified to 157 days. Trinity Pines owns 3 parcels. I have listed them on my cover letter by parcel number. On RPC 00000010005, the total land value was $354,414. I divided that by 365 days to come up with $971 of assessed value per day. I multiplied that by 157 days, and the new assessed value that I'm requesting is $152,447. For parcel number RPC 00000062425, the land value came in at $443,726. I divided that by 365 days to come up with a per day assessed value of $1,259.69. I multiplied that by 157 days to come out with a $190,863 assessed value on the land. And then the improvements, I did the same. The improvements came in at $8,041,529, divided it by 365 for a per day assessed value of $22,031.59. Multiplied that by 157 days to come up with a new assessed value for the improvements on this parcel of $3,458,960. On parcel number RPC 00000064215, I did the same calculations. The land came in at $120,102, divided that by 365 to come up with a per day assessed value of $329.05. I multiplied that by 157 days for a new land assessed value of $51,661. The improvements came in at let me back up. The improvements came in at $3,315. I divided that by 365 days to come up with $9.09 assessed value per day, multiplied it by 157 days for a total assessed value on the improvements of $1,427. I also want to make the board aware that Trinity Pines inquired about a timber exemption. So I sent them a timber packet because I believe that the big parcel to the west is completely timbered. Yeah, I mean, they would definitely qualify on that parcel. And then any timber on the other two parcels, if they were to hire a forester to cruise all three parcels, whatever the forester indicates that it would qualify for a timber exemption on. Obviously, I take that management plan and I take that information of how many acres would qualify. I apply it in our system. And then in that same management plan, it would tell me if it should be considered good, medium, or poor class timber. I'm assuming that since they asked for that packet and they're interested in the timber exemption, that they will submit all of that to me by December 31st, which is the deadline per Idaho code. And then we could calculate the timber exemption and put it in a timber exemption of what qualified for it for 2025
But it won't qualify for this year.
No, well, they would have had to have submitted
Right,
everything to
right.
me by December 31st of 2023 for Idaho code. So, so I have included code 63-602B in my packet. I also included the ADAPA rule 35-01-03-603. And then I also included the Sawtooth Valley Chapel versus Custer County 2022 Idaho Board Tax Appeals decision. And in that decision, it outlines that there's two qualifying criteria for a religious exemption, that the property belongs to a religious organization, and that the property is used exclusively for religious, educational, or recreational purposes of such religious organization. When it was determined that the property was rented to other organizations, those were the days that we considered a commercial use. It goes on to say that they must apply and qualify each year. And then on down further, it does state in this Board of Tax Appeal decision that renting a venue to religious organizations is not itself a religious purpose or use. In other words, if they're renting it to the Mormon church, let's just say, they're not going to consider that a religious purpose because they're letting someone else use the property. The owner's using the property, it's exempt. As long as they're using it for purposes that are stated in their articles of incorporation. It goes on to page 6 in the same BTA decision, must be used exclusively for and in connection with any combination of such religious organization, corporation, etc. The statute unequivocally states the property must be used in furtherance of the owner's religious purposes, not those of another religious organization. I also included the process used to determine the 63-602B exemptions, the process that we went through, looking at each 602B application. We determined if it was owned by a qualifying entity. We looked at the articles of incorporation to determine if the applicant is a religious LLC or corporation. We checked the deed to make sure the property owner matches the applicant. Then we moved on to determine if the property was used exclusively for religious, educational, or recreational purposes of the owner of the subject property. We reviewed the articles of incorporation and bylaws to determine what the property owner's stated religious purpose is. The applicant's purpose statement is in their own organizational documents and were used for the basis of making the determination. We compared the applicant's religious purpose found in its organizational documents with the actual use of the property over the course of the prior calendar year. Use was determined by evaluating the following. We reviewed the answers provided by the applicant to the questionnaire. Applicants were asked to provide a calendar of events showing what organization used the property and the type of activities that were occurring on the property. We also reviewed the applicant's website to evaluate how the applicant was marketing the property. The property must be used exclusively for religious, educational, or recreational purposes of the owner of the subject property. Property tax exemptions are granted based on the use of the property. Period. So the days that were rented to other religious organizations, secular groups, schools, government organizations were recommended as non-qualifying business or commercial uses. So at that point, we had to determine if the applicant was entitled to a partial approval of its application, as so stated in the ADAPA rules that both the appellant and I have provided to you. It was based on the calendar provided to the assessor. The assessor had to determine what days were rented to other religious organizations, etc. And we had to provide a property tax assessment for those days of use, which we did. We did reach out to each entity to go over the calendar provided in the application to make sure that we understood which entities were of the owner and which entities were not of the owner. If the owner used the property for its own religious purpose of the property, they were granted the exemption. If the property was idle or not being rented to another organization, the exemption was also recommended. If only a portion of the property was used or leased to a third party, then an evaluation determined if that portion rented was valued at 3% or less of the value of the whole property. And we only would know that if they submitted that information on their application. We can only go off of what they send us. So it's actually very rare that the 3% Dominicus rule comes into play. However, from time to time, there are qualifying entities that are under that 3% rule. And it's not 3% of the square footage, it's 3% of the total value of the entire property. Next step, the use or lease of any property by a religious corporation for athletic, recreational facilities, resident halls or dormitories, meeting rooms or halls, auditoriums or club rooms for and in connection with the purchase for which the religious corporation is organized shall not be deemed a business or commercial use. So we took all those things into consideration. The next pages in the packet are just printed off from their website. All the things that Trinity Pines has to offer. And then the very last couple of pages is the calendar from Trinity Pines. The yellow highlights were from the Nazarene Church. And then when Christy went back and recalculated after making sure we didn't count double days when there was two different organizations using the property, that is in green. And so that was our request to modify your original decision to 157 days of commercial use. rather than 218 days. So after reviewing Idaho Code 63-602B and the ADAPA rule, we believe that Trinity Pines complied with Idaho Code for 208 days during 2023. We also believe that the property was used for commercial purposes for 157 days during 2023. I respectfully request that the Board of Equalization modify the 2024 assessed value for all three parcels combined to $3,855,358.
Okay, any questions for the assessor? No, I'm good. So at this time, Randy, you have a chance to rebut anything that you heard or see. Please try to keep it short. That's where our hour is up.
First of all, I'm glad that the county assessor doesn't have a JD after her name, and I don't have to meet her in court. She did a very nice job. Number two, we did inquire about that timber exemption. We're not seeking it. We have retained John Lillyhog, who used to be a forester with the State Department of Lands, and he's going to provide us two plans, one for purposes of that exemption, the other one for purposes of fire danger. I am personally getting involved, highly involved in the fire danger issue and working with the people here in Valley County about that. I think that in essence, this comes down to what are the owner's religious purposes. And when we started out with Trinity Pines, we wanted to broaden our base. We wanted to provide a camping experience to other people. And that's what we're doing. That's what our mission statement says. And that is, in our view, that's our religious purpose. That's part of it. And we're providing a very important service to a lot of different people. More than 11,000 people went through that campground last year. And so we would ask that the exemption be granted in full. And thank you for your patience. As is often the case, I went over my time, and I appreciate your indulgence.
Okay, thanks, Randy. So at this time, we'll take it back for deliberations, and I guess there's a couple of things that kind of tripped me up. The first one was the RV park. When your policy on it kind of states you have 24 spaces, full electric, water, all, and you go all the way through all that, but there's nothing in that that says you have to be a volunteer or a Nazarene. So to me, that basically says anybody could camp there. The way it is sold on the website, to me then is a business use of a religious exemption. I think there's some things that you guys could do to probably tighten up some of that stuff, to look at it in a different light. I think it may be that you want to continue with that function, knowing that you're going to be taxed on it, but the income will more than generate the revenue to pay the tax. And that is business model, business decision. And that's what we've told all the church camps. You may want to continue doing this. It's not that we're trying to stop you from doing that, but just know that you will be taxed on that representation. So that, and I think with the decision that has, with the discussion today, I'm pretty solid in the fact that I believe the assessor is correct. So I'm going to make a motion that we.
Mr. Chairman, the assessor would like to.
Oh, I'm sorry.
I have one more thing I would like to add if allowed. I want to put on the record how the process that we used to determine the 602C exemptions. I want to put that on the record today. Right now, if you'll allow me. Sorry. I just want you to know that the process that we used to determine the 602C exemptions, I think that's really important. because most of your exhibits, you're referring to the 602C applicants. So I'd like to put it on the record. So the process that was used to determine 63-602C exemptions is as follows. Step one, we determined if the property is owned by a qualifying fraternal, benevolent, or charitable LLC, corporation, or society of this state. In doing so, we review the articles of incorporation to determine if the applicant is organized as a charitable LLC or corporation. We check the deed to make sure the property owner matches the applicant. And then we considered the 8-part test outlined below. The Idaho Supreme Court developed an 8-part test to determine the charitable status of a nonprofit corporation applying for a property tax exemption. That analysis includes the following factors. Factor 1, the stated purpose of its undertaking. Step 2, whether its functions are charitable. Step 3, whether it was supported by donations. Step 4, whether the recipients of its services are required to pay for the assistance they receive. And 5, whether there is a general public benefit. Number 6, whether the income received produces a profit. And 7, to whom the assets would go upon dissolution of the operation. Step 8, whether the charity provided is based on need. Step 2, we needed to determine if the property was used exclusively for the charitable purpose of the owner of the subject property. In doing so, we reviewed the applicant's articles of incorporation and bylaws to determine what the property owner's stated charitable purpose is. Articles of incorporation or organization will outline what the corporation or LLC's charitable purpose is. The applicant's purpose statement in their own organizational documents were used for the basis of making the determination in step 2. We compared the applicant's charitable purpose found in its organizational documents with the actual use of the property over the course of the prior calendar year. Use was determined by evaluating the following. We reviewed the answers provided by the applicant to the questionnaire. The applicants were asked to provide a calendar of events showing what organization used the property and the type of activities that were occurring on the property. We reviewed the applicant's website to evaluate how the applicant was marketing the property. And once again, the property must be used exclusively for a charitable purpose of the owner of the subject property. Property tax exemptions are granted based on use of the property. For example, you have to ask yourself, so how is the applicant using the property when it rents its property to another church, charitable organization, or secular group? When a property is rented to another group, the owner is using the property like a resort property, commercial campground, or event center. Even if it's another nonprofit corporation, the applicant's use of the property during that rental period is as a camp host, if you will. They take the reservations, they cater the meals, they're cleaning the cabins or the facility, they're selling merchandise, etc. Days rented to the other religious organizations, secular groups, schools, government organizations were recommended as non-qualifying and were considered a business or commercial use. Step 3, we determined if the applicant is entitled to a partial approval of its application. The Idaho State Tax Commission has adopted IDAPA Rule 35-01-03-603, giving us guidance on how to calculate those days of commercial use. Based on the calendar provided to the assessor determined what days were rented to other religious organizations, secular groups, schools, government organizations, and provided a property tax estimate for those days of use. If the owner used the property for its own charitable purpose, or the property was idle or not rented to another organization, the exemption was granted. Step 4, we took into consideration, once again, the 3% Dominicus rule. So if only a portion of the property was used or leased to a third party, then an evaluation to determine if that portion rented was valued at 3% or less of the value of the whole property combined. This is usually a very rare occurrence, but we have come across it, and we followed Idaho code. Step 5, to use or lease. The use or lease of any property by a charitable corporation for athletic or recreational facilities, resident halls or dormitories, meeting rooms or halls, auditoriums or club rooms, for and in connection with the purpose for which the charitable corporation is organized, shall not be deemed a business or commercial use. The question that we that we must answer with the 602C applications is, what is the community benefit that this property provides, or does this operation benefit themselves? That is the question that we have to ask ourselves. Okay, thank you. I wanted to get that on the record.
So Sue, I got a question for you
Yep.
real quick on that. Because I know like Valley County Gun Club, we have a benefit every year in September. And so we rent the American Legion Hall. And they're a nonprofit organization, just like the Valley County Gun Club is. So we lease that from them, you know, one charitable to another, even though has nothing to do with any religious, it's just a 602C. How do we look at that as a board?
Well, you'd have to go back to the Articles of Incorporation and the bylaws to see what is stated, because every organization's Articles of Incorporation and bylaws are different.
Right.
And so we have to compare the use of the property to what they state in their own organizational documents. And we have to compare it to the calendar of who used the property.
Okay.
So it's a little different for every organization, because every organization has their own Articles of Incorporation and bylaws that we had to review.
Okay, I'm just curious.
So Sue, just for the record too, this appeal was under 602B
B,
religious.
yes.
This was not a
Yes.
charitable appeal.
Yep.
How do you make the determination that, I'm just gonna ask, maybe they would be better off coming under a C instead of a B?
That is not up to
That's
me.
their
That
call,
is
correct?
up to each
Yeah.
entity.
Right,
They're the ones telling us what code that they're
Right.
applying under. We don't determine that.
It's still use of property anyway. So, I mean, we really look at almost exactly the same thing.
Yeah.
It's still how the property is being used daily.
okay, any more questions for Sue? No?
Mr. Chairman, because FERPA has been brought up in this, I think that we should go back to legal counsel just to review and do make this pending upon a written decision on July 8th, just to give us a chance to cover all bases.
You feel the same way?
I'm good with that.
Okay, so then we're gonna postpone this one until July 8th for our final decision. Randy, thank you very much for coming in and presenting your side of the argument. And as you know, if you're not happy with our decision, you can appeal it to the state BTA and then, or district court, or probably both, so.
And I appreciate all your time. I really do. I know you gave me extra time, and I don't find many people in the world that do that for me. So,
Alrighty, we'll take a 10-minute break and then we'll come back. We have one more appeal to do this morning, and I think that's it.
Thank you, Randy.
CM 2408. I read that right. The letters are really getting smaller. Yeah, CM24. So let's come
I'll
back
try to
in
make it
about,
bigger font next year, I'm sorry.
about 10 minutes, 5 till.
Put it on a
Hi, Bob.
Mr. Chairman.
Okay, welcome back, everybody on YouTube and those in the audience. We're at the last agenda item for BOE this morning. This is appeal number CM2408, Robert Beatty. Robert, will you please rise and raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help me God?
I do.
Thank you, sir. Please state your name for the record.
Robert Beatty.
Okay, thank you. As you know, we allocate about an hour for this, but I don't think this will take too long. Before we get started, I'll ask if anyone on this board has any ex parte or conflict of interest.
I do not.
And I do not. So at this time, Robert, I'll give you 15 minutes to explain your case and we'll go from there.
Thanks. All right. Okay. So and I know assessors are required by statute to value all property at market value. It is not the highest, lowest, or average price. Market value is defined by code 63-201.10 as the amount of United States dollars or equivalent for which in all probability, a property would exchange hands between a willing seller under no compulsion to sell and an informed, capable buyer with reasonable time allowed to consummate a sale, substantiated by a reasonable down or full cash payment. I think I've taken the probability out of that I purchased the property for $42,000 in March of 2023. That's my property on the screen there, 116 Herrick Lane. This was an arm's length transaction in the open market with a willing buyer and seller, no advantage to either party, and the property had reasonable exposure time prior to purchase. Appeal instructions state the taxpayer has the burden of proving the assessor is wrong, but the only proof would be from sales data, which I submit. It's almost impossible to get in my neighborhood. And I'll show that later, but I am able to show that my current neighborhood, which is 4,800, is not a good fit for the South Round Valley subdivisions. So that'd be Snow Haven Sub 1, Sub 2. Snow Haven subdivision is overpriced looking at the last 2 years of sales. And smaller sized properties are overvalued compared to larger properties. And less expensive sales have much higher assessment ratios versus higher price sales. Let's start the first one. We use the principle of substitution to set market value within each neighborhood. Principle states a property's value tends to be set by potential cost of acquiring equally desirable substitute property. My property is 0.52 acres on a busy dirt road in South Round Valley. Most of the properties in my subdivision consist of manufactured homes, RVs, and cargo containers, or bare lots, and there's really no trees in this area. So this neighborhood consists of 1,183 total parcels, and the average size of a parcel in this neighborhood is 14.8 acres, and the median size is 2.8 acres. There's a total of 5 fair grade land parcels under 0.9 acres in this neighborhood. So that would be my total group that I could compare to, 5 total parcels. So you can't run statistics on 5 parcels. And the likelihood of them even selling is even crazier. So I don't think this is fair and equitable for my subdivision or my property. If you look at illustration 1, my property is in a saddle. And I'm basically, if you zoom in really close, you might be able to see it on this. My pictures came from Google Earth. You can kind of see the valley going right down the center, cutting the property, which is a spring drain off from the properties above me. So that's a mud hole. I can't have septic within 50 feet of it on either side. It makes it difficult to build. It definitely brings down the value of my property.
So you have 5 acres there?
0.5.
Half an acre.
Yeah, I have 0.5. There's a total of 5 properties in this whole neighborhood that have under 0.9 acres.
So, okay.
So I was just saying, there's most lots in this neighborhood are over 2 acres. The median is 2.8, the average is 14.
Lot of egg.
So the next page is kind of the summary of all the parcels in this neighborhood on the size. And I kind of just put a quick graph so you can just clearly see that there's not very many small parcels. So number 2, I'd like to submit the neighborhood 4800 does not reflect South Round Valley subdivisions. There have been many sales in Snow Haven subdivision and the close surrounding areas in the last 2 years. And if you look at this chart, I numbered 1 through 9, and 8 of those are in Snow Haven sub 1. So you can't say there's not enough sales to determine that the prices are overvalued there. The first one was mine. It's 152% sales to assessment ratio. The second one's 129%. The third one's 127%. Fourth one on the list is 98%. The next one's 144% sales to assessment ratio. Then 125%, then 101%, 140, and then 136. So 8 out of the 9 sales are over 100% sales to assessment ratio, and most of them by quite a bit. So I also did a ratio or a sales chart on the next page. It shows the sales data ratios clearly show that the parcels that are less than 1 acre are not treated fairly and equitably compared to larger parcels in neighborhood 4800. So this chart shows the lighter is the sales price and the darker is the assessed price. So the larger the acreage, the lower the assessed price, even though the sales price is higher. So these people are like 80% sales ratio, where anybody under 1 acre is basically paying over what they paid for their property. So lots under 1 acre have an average ratio of 127% sales to assessment, with 3 out of 4 parcels being overvalued. Compared to parcels over 1 acre, with an average of 89.6% sales to assessment ratio, with 16 out of 18 parcels being undervalued. So I think this shows a clear misrepresentation of value for lower parcels not dependent on grade. This is all sales. And then finally, on the last page, or the second to last page. So I also charted the sales data ratios clearly show that parcels that are sold for under 100,000 are unfairly treated with higher ratios compared to sales over 100,000. So this chart's the same thing, but it's instead of sorted by size, it's sorted by price. So the more money you spend, the less you're assessed. And things under 100,000 are assessed over 100% value. So in conclusion, I purchased my property in March of 2023 for a sum of $42,000 when it was assessed at $59,664 as of January 1st, 2023. To my surprise, the assessment increased again this year to $65,630 for January 1st, 9 months after I purchased it. There was only 2 qualified fair value sales under 1 acre in 2023. Debates the increase for my neighborhood, so I don't understand why it increased. The first sale was mine, which has a spring runoff. And then the second sale is at the end of that cul-de-sac on top of the hill, to the left.
Just a little to the left.
The more wide looking one,
Just up ahead.
straight up, that one.
That one.
Which I don't think that is comparable property to my property. They don't have the spring runoff. I don't think it's a 1-to-1. They're fair, I'm fair, but I don't think that's a fair comparable. when you look at it. They don't have the difficulties I have, and they don't have the dust storm from Herrick every time somebody drives by. I think I've clearly shown that my values are determined from a neighborhood of properties that don't represent my property or my neighborhood or my subdivision. I believe I've shown that lower size and lower sales price properties are overvalued compared to larger size and larger sale price properties. I hope you take all these things into consideration. And that's it. Thanks.
Robert, have you tried to get a septic permit? I didn't think you
Yes.
could even get a septic permit on that.
Nope, I just passed the spring, but I got this small little section, so I can do a 1-bedroom.
You can, that was my question. This is a picture of your lot,
Yep.
correct? And up in this side up here, the higher side, that's I'm assuming where you get
Yep, that's where, right up in that, like, the,
dog.
yeah.
But you can put a well and a septic on that?
It's a 200-foot long and 100-foot wide, I think. So, yeah, I have my well
There, yeah.
down low by the driveway, and then the septic will be 100 foot away, kind of where it crosses over up top into that smaller section. So, and then I have to be 50 foot away from that other part. So when it all comes down to it, I have really good dirt. So he said I could put it in a 1-bedroom.
Okay, any more questions for the appellant?
I think so.
I'll turn it over to Sue.
Craig.
Great, okay.
So I passed the appeal and a couple of sheets at the back are mine. Little bit of history. It is a difficult property to price. All of them in Valley County are unique. It seems like now stuff that's selling is the stuff that it was held back. All the prime properties have passed around. We're getting a lot of features like, I guess you could call it a saddle. Ability saddle, hillside. What we used to consider as undesirable is becoming more desirable. People are building on it, making it happen. I have the job this summer to go through this area and reevaluate the land grades. Because the fares are probably not as fair as they used to be. And then we'll let the price adjust for the features. I think in our county, we had all countywide 5 properties sold. That's just land owned. We only had about 150, a little over 150 land only sales. So finding a land only sale is so our consultant at Idaho State, our consultant appraiser at the State Department, met with us, and she indicated that we were actually in the southern end of this valley. We're in our ratios, but as things are pushing this way, the prices are coming. So to really try to price this property, and Bob's right in his little microcosm right there, it is unfair. So we opened it up. And we opened it up to Southern Valley. The properties that I have listed here are from Cascade on down. They're similar. You'll see them in the flats over on West Mountain. A little bit of Cascade, south of Cascade, down in Gold Dust, and down in his area also. They're smaller lots. The higher prices are hitting on the smaller lots. When you get down on the square footage, your ratios are going to change. They're going to look and appear overpriced. But if you can look at page 1, make it a copy, please. So if you look at this overview, it starts at the top and moves down. And admittedly, the last in the 314 400s, those are some lots that are similar size, a little bit
little bit bigger, not so much. Have a lot of indication of terrain, like Bob's. And it is in Crown Point.
And which property is that? I'm sorry.
The 314-400s towards the bottom.
Okay.
So you look at the ratio and all the averages, you can look at the size, 0.57, look at the sale amount, time adjusted to the right. We're at 94.7, which is less. His is 0.52, the comps are coming in at 0.57. We're saying at that point, including that Crown Point, we're at 72,650. This is 65,630. So I took it one step further and I did square footage on the lots. I took the price to the square footage of the lot to see where we really hit, to take that size difference out. Look in the lower right-hand corner, Bob's is 289.7 a square foot. The comps came in at 275, which means we were a little bit higher, 4.83% higher per square foot. Now, if you go to the second page, I took the exact same lots, ground, and I took Crown Point out. Removed it, to be fair, kept on this side of Cascade. It didn't do it any favors. It actually was a detriment to the appeal. We came in at 57.58 cents less on his property. So, and I need to remind everybody that even though we're comparing ground, land, and it was a land sale, that was bare ground that we bought. It was what we call an outlier. It was an odd sale. People are coming in, we're having a hard time chasing them. You don't know whether it's a fire sale, a divorce sale, somebody got tired, economics, but you know what happens? We're doing the same thing in Crown. We're up and down and all that. So, one thing I can tell you, to the best of my knowledge, is that these are bare ground. In 23, and our system isn't really prepared until you put an improvement on it to account for these improvements. But in 23, Bob put a well in. I'm guessing minimum 20 grand. Excavated it, put power in. He's living there, all in 23. And we still didn't account for that. That's not accounted in this. These are bare ground, bare ground, bare ground. So when you say, make statements like, well, I can't sell that for 42,000, or I can't sell that for 65,000. With the improvements that you put into it in 23, I believe you can. And in good conscience, even though our Matt's appraisal, which is pretty accurate, it has its hiccups, I believe in it, you can adjust and make that work.
Greg, I have a question for you. So when this sold at the 42,000, I'm assuming that Bob let the sales amount out.
He filed and told us that.
So do we account for that reduction at that time because he bought it in 23 at 42, but we still had the 59,664.
So did not account for that.
That would have been from the previous year. The sales that occurred the previous year. So we had to analyze the 2023 sales to set the 2024 values. So we did the same thing a year prior to that. We would have looked at the 2022 sales to set the 2023 assessed values.
But he didn't buy it until March of 23.
Correct.
So that value at the 59,664 was what was out there. You got a good deal on the property at 42. So when he notified us, hey, I bought this at 42, how do you guys
The sale
account?
was used in the analysis. The problem is we don't do fee appraisals. We do mass appraisal. So when Bob speaks that there isn't any sales in his immediate neighborhood or subdivision, well, that happens all over the county. And so if we don't, of course, we try to find comps closest to him. But if we don't have them, then we have to broaden our search. And so I personally put together, I don't know, about 20, can I have that piece of paper? About 20 sales, just kind of down and dirty quick when him and I were talking about this. And his sale is included in this. But the average acre, so the average of those 20 sales was 0.57 of an acre, which is just a little bigger than what he has. The average sale amount for those 20 sales came in at $72,651. The time adjusted sale price, because we had to add 0.25% per month. So the average time adjusted sale came in at $73,693. So the average size came in at 0.57. Bob's at 0.52. The average time adjusted price came in at $73,693, and Bob is assessed at $65,630. So yes, we used his sale in our analysis, and as a comp. I believe our assessed value is fair and equitable because we don't do fee appraisals, we do mass appraisal.
And Bob, so you know what the process is. We just walk through that process. Where is the process broken, in your opinion?
In my opinion, so they didn't show you a map of any of these properties. When Sue showed, I looked up some of the ones she showed me. They were West Mountain, Crown Point, close to the lake. They're camp properties that people are buying for recreation. Nobody's buying recreation sites here.
I sold one of those within 2 lots of yours.
Yeah.
Just to let you have.
So it's on my list, right?
I'm sorry?
It's probably on the list that I gave you then, right? Because
It is, and that was for recreation. I mean, that's.
Well,
People are. So.
not the same as West Mountain recreation, I guess what I'm saying. I mean,
Because you can't leave your home.
well, you can't get to the lake. I mean, you can't just drive a 4-wheeler down the lake.
You can go Skunk Creek though, and go up Clear Creek.
Yeah, well, yeah.
So it's just a different form of recreation.
Yeah, but people pay more money to live up there. They'll pay $100,000 for a sanitation lot up there that you can't even get sanitation on. Nobody's paying that in my neighborhood. I mean, I showed you 10 sales right here that are overpriced. And that's just being ignored.
However,
That's-
we passed our ratio study with the state tax commission. And as long as we're within compliance with the state tax commission, that tells us that we're okay.
Bob, when you bought this, did you know the assessed value at that time that the county had?
No, I didn't look at it, I don't think. I can't remember if I did or not, to tell you the truth. I just knew it was the only thing I could afford at the time. I didn't buy it because I was like, oh, this is an awesome lot, I'm gonna buy it. I bought it because it's what I could afford. And I think it was a fair price. And to say it was an outlier without even looking at it was, I can't compare myself to those lots on West Mountain. I don't have a treed, sunny, shady lot. I mean, I don't think it's fair to compare me to places like that.
Okay.
I think it was a fair price for what I paid, the same as all my neighbors. They paid fair prices, but they're being assessed at 140%, 130%. So why are we, just because it's easy to say, oh, we got to look at mass appraisal, we're not gonna look at what you paid and take into considerations the issues that you have in your little area, because that's just one little subdivision, and we didn't use your stuff in the ratio study anyway. So, not in the ratio study.
Your sale was in the ratio
Not
study.
in not in that ratio study. It was used for Anthony's comps, but it's not used in the ratio study.
I know.
Okay, so let's not go down this road.
Okay.
You kind of crazy the statement that you did or didn't do a well.
I had it well dug. I do not have water yet because I haven't had the amenities, and nobody in Valley County is assessed on a wellhead. That's what I have, is a
What do you mean you
wellhead.
don't have amenities? You don't have power?
No, I have a power. I don't have the pump and
Oh, okay.
the electric
But
to
you
the
have a
pump,
well.
and I have the well drilled. I haven't had a drop of water out of it yet.
Okay, and then you have a permit for a one-bedroom house.
Yes.
Solid.
So I've done things, but nobody else in Valley County's assessed these things. So
Well, I think the issue on
What's the
that
fairness
argument
of
is the fact that I could sell my kids my whole ranch for $1. So do you appraise a ranch at $1?
no, because that's not a fair handshake deal. I mean, there's rules about
It's not an arm's length transaction.
yeah, there's rules about arm's length transactions, and yeah, that sat on the market for weeks. And I looked at it and was like, man, that place is ugly. And in the end, yeah, I did want to go after and buy it. But it's not like it was on the market for a day and I just grabbed it and I got an awesome deal. You know what I'm saying?
But I don't understand why you wouldn't at least look up what it was assessed at by the county assessor before you bought it.
I may or may not have, but I don't.
Because I think that would be an indication of value. You got a hell of a deal. I'm proud of you, man. That's awesome. And I think that could be really fixed up to a beautiful.
Oh, I think, yeah, if you put a lot of money into it,
Yeah,
yeah, it can be.
and I think that if you were to get it at the timed adjustment value, that's what we really got to look at. You can't look at what you paid for
I had
it.
it for 9 months and it went from 42 to 65. There's,
You do realize we've heard this story over and over again. in the last 2 years.
oh, yeah, I know. But do you know Cascade, Lakefront values went down this year. West Mountain went down this year. But you're telling me the crappier neighborhoods are going up this year. And I'm seeing what sales are you looking at for this area? I mean, yeah, you can look at all Valley County and you can find spots that are going up.
We didn't look at all of Valley County. We looked at sales Cascade and Cascade South because we didn't have anything in your immediate area. We do mass appraisal.
I know you do mass
Can
appraisal.
I add a couple things?
Sure.
You know, it's not a crappy area. It isn't.
No, it's not.
One thing, if a person says, hey, I don't like this spot, I got dust. Another person says, that road is plowed every day. And they love it. It is a premium spot. It's on a bus route. So there are different reasonings as to why people buy it. Understand. That upper corner on Gammon and Skidoo, come back there. That big elbow-looking thing. No, you're right. It's just one up on Skidoo and go all the way to the corner
The other way.
left on the screen.
Gammon?
Right there. That gentleman actually put in for a permit, a use permit. I'm not sure he got it, but he excavated that whole corner out. He took a not such a great place. His RV hookups in there, the area's meant for family. It's usable. He moved down that hill, and they're doing the same thing, the next lot down. That one right there. I drove past it, it's got swing sets out there, it's got children's playhouses. They made it into RVs, and that's exactly what they're doing. It's a real difference. Putting their amenities in. The lot says that area up there in the crystal core, should continue the other direction, that odd-shaped lot that's sold right there. It's similar to his, especially whenever you take out the easements off the sides, that you can actually use that lot. I walked up there, it drops off to the left and feeds, but logs in. That is not a level lot. It's not all uphill, downhill. Half of that lot drops off. And you would probably say, how in the heck am I gonna? It's not that out of whack.
So the drainage ditch goes through that parcel that's sold.
It begins that is actually a draw. The point on the left of that is the high side,
Okay.
and it all comes down in through there. So
Yeah, I see it,
probably
I
a third
think.
of that lot is involved. And you take all of your setbacks, front and back sides, it's gonna be a son of a gun to get anything on that, and someone decided that they wanted to buy it. Put a well on that, and then you try to figure out where to put your sewer. So I'm not saying that it's a great lot, but it's a good lot for comparison to it. There are lots in here. It's not around here. People are moving that way, people are buying, they're selling. Just around the corner in Up Gammon, there's some high-end homes, really, really close.
Okay,
Can I ask a question, please?
sure.
So, Bob, on your appeal form.
Yeah.
You're asking for your lot to be valued at $42,000, which is exactly what you paid for it, correct?
Yeah, because I noticed that the sales are actually going down year to year in that neighborhood, so. I know when we do time trends, it's for all of Valley County, and you take an average, and you say, okay, this year it's 0.4.
So I noticed you didn't take it into account, you didn't time trend your sale amount and request a time trended assessed value, correct?
No.
Okay.
I time trended all those in the chart to show what they paid for them, what the time trend, if we went by the county's time trend. And then I put the ratio from sales to assessment.
Well, as I explained, we don't live in California and we don't live by California rules and we don't have Prop 13. People there pay taxes on what they pay for their property. That is not how Idaho's property tax system works, as you know.
Yep.
I pulled together 20 sales just to prove a point that I could find those sales. They weren't right in his neighborhood. They weren't next door, but they were Cascade South. So I believe because we do mass appraisal, that Bob's value is fair. Bob, would you sell your lot for $42,000?
I don't know. I don't think that's a question. Do you not think there should be any discount for having the drainage in the
Your
center?
discount is in your land grade. You are being
I'm the same land grade as the guy that doesn't have the drainage.
You are being assessed. We have some land grading issues in Round Valley, as you know. So they're in our reappraisal the year after next. I've actually asked Craig that when he's done doing his reappraisal to go down to Round Valley and start really digging into correcting these land grades. And you and I have talked about this. We both know that there's some issues down there.
So yours isn't fair. Some of the other ones are still at average. So-
There's a lot of
There's
fairs in
some of
there,
them
actually.
Graded as fares that should be averages down there.
So the one at the end of the cul-de-sac is a fair. I think,
So we can't reduce yours from average to fair. I mean, it's already fair. You've already
It's
gotten
already
the
fair.
break.
right, that's what well, I don't call it a break. I mean, there's other fairs in there that don't have their lot cut in half by spring drainage, where it's,
So what I'm hearing you ask is because you feel like the lot is compromised because of that drain.
yes.
You feel like you should be given a percentage value off.
No, I feel I paid a fair value, but I also see all the neighbors are overvalued too, if I look at their statistics. So it's
So is
not
that,
just my place,
I want to
but
respond to that really quick. So when you're saying that they are overvalued, again, they passed the state. I mean, you can't be more than 10% overvalued. You've got valuations here that you're showing are 50% overvalued,
that's,
150% overvalued.
yeah, that's true.
Well, why didn't the state flag those?
I don't know, maybe they should be asked that, because I don't think they're using these sales as, one, they don't use 22 sales.
Nor should we.
You're completely ignoring what I told you about the end of this. That has that same type of drainage as you have. It's a fair.
There's no mud hole in this, cutting theirs in half, but that's a different topic. My topic was
I have
the,
pictures of your lot before you started excavating it. It wasn't a mud hole.
it's still, this is the picture.
Now, but that's not.
I didn't cause that.
Well, we all get spring runoff. Every single one of us.
Okay.
Bob.
I have the picture right here
Excuse me, I'm
of the
talking.
lot. I'm sorry.
Bob has a drainage ditch, if you will, down the middle of his lot. And because he has that, we have put a fair land grade to account for the detriments to that lot. Now, are all of the other parcels in that area that are graded fair, are they graded correctly? No, they're not. We have an issue. but we can only do so much every year. So if Craig has time after he is done with his reappraisal in the Cascade area, he's gonna go down to Round Valley, which isn't until the following appraisal year. And he's gonna go down and try to get some of these land grades corrected because I've asked him to, because we have an issue.
Okay, we gotta wind this up. Any more questions, concerns?
I don't.
I guess in my case, it comes back to knowing that the appraised value when you bought this was a lot higher than what you paid for. Would have been, to me, the first thing I want to know. What are my taxes going to be on this place? And I think that's kind of a weak argument saying I didn't look. I think you did get a good buy. You've got that benefit. You've got that equity already built in your place, which is worth a lot. And I think it's hard to find comparables on every lot in Valley County. If you think about it, they're all a little bit different. But like Sue said, we do this on a time basis, a wider basis. It's not in each individual land sale. I think it's a fair value that has been presented. So I'm going to make the motion that we deny the appeal and accept the appraised value of $72,104. Do I have a second?
Second.
Okay, we got a motion and a second. Everyone understand the motion? Okay, all in favor, please say aye.
Aye.
Aye. Motion carries.
I'm kind of going back, I'll be honest with you, is selling real estate in this county for as long as I did. It's hard to find a lot for 65,000 you can put a well and a septic on. So it's like, you know, I mean, there is value in the fact that you can get a building permit, a well and a septic on a piece of ground in this
Absolutely.
county. And, you know, I mean, it's just flat hard to find anything even at that value. So I think you did get a great buy.
Okay, so this will be the last agenda item on our BOE for today. This